Well, welcome, everyone. For those of you in the audience that may not know me, I am Greg Whitcup. I'm director of both Cranbrook Art Museum as well as the Cranbrook Center for Collections and Research. On behalf of my colleagues at the Art Museum, the Art Academy, and especially the Academy of Art Library, I'd like to welcome everyone to our workshop this afternoon. I can tell that this is an audience that probably has a lower percentage of artists and probably a higher percentage of librarians and registrars and people like that, because you have all been sitting here in your seats waiting for this to start promptly on time, which is usually not the case where everybody begins pouring in right now. And yes, we are really delighted to have here at Cranbrook the group that we like to think are the imposter CAA, because of course we go by the acronym CAA here at Cranbrook Academy of Art, as does the College Art Association. I first began thinking about fair use in a really serious way about 15 years ago when we received a wonderful collection here of modern and contemporary art that had all the big names in the field in it. And as I very excitedly started thinking about the catalog we were going to publish and, the invitation to the opening and all these related materials, and our registrar at that time said, "Oh, Greg, slow down. We have to start getting permissions to use all these images. We may own them, but we still have to ask for permission to use all of these images." Well, we did, and we paid back then probably even more money than what is often being asked today. And over the past 15 years, we just kind of added it to the cost of doing business. We really thought, okay, we're going to stay above the boards here, and we're just going to go out and ask all the rights organizations and the states for permission, and if their price is too high, well, we won't publish it. Well, a few years ago, as I think many of us began learning about the College Art Association's initiative to begin really seriously exploring fair use in the visual arts, and with the goal of drafting a policy, I was certainly one of the first to applaud this charge that they were taking. The College Art Association is now beginning to unroll, if you will, the policy through a series of these workshops across the nation. We're very honored to be able to host one here at Cranbrook. Of course, it's always nice when the president of the College Art Association is a former employee of the Detroit Institute of Arts, as is one of our two presenters today. So there are certainly long and deep ties between the College Art Association and the metropolitan Detroit area. Before I introduce our experts today, I just want to give you a little better sense of how the afternoon is going to unfold, and I especially want to introduce my colleague and co-organizer on this workshop, Judy Dykey, who is the library director here at Cranbrook Academy of Art. The way that this is going to unfold is that our two speakers from College Art Association are going to come up here and give us a nice overview of the whole policy. We then, Judy and I, invited 5 people in the community that are leading different type of institutions or departments within institutions for whom the issue of fair use is quite regularly on their mind. And so we thought it would be nice, before we open it up to question and answer, to have those 5 people come up and maybe just shed a little bit more focused light on certain areas of the policy, and then we will of course be opening it up for Q&A, because I know that you're all going to have a lot of questions. We've left a lot of time in the afternoon for for that particular portion of it, and so I think that that's where we'll also learn a lot about it. We're not going to take an official break, so I just want to make sure everybody knows where restrooms are, and if you need to step out for a moment, don't worry about it. But in the Harry Bertoia show, which is in the gallery immediately outside the doors, the ladies' room is in the far left corner, the men's room is in the far right corner. And Judy will be the one that will be coming up to the podium and just briefly introducing the 5 respondents when we get to that portion of it. So very briefly, I would like to introduce our 2 main speakers today, starting with Patricia Aufderheide. Patricia is a university professor in the School of Communications at American University and founder of the Center for Media and Social Impact there. Her books include Reclaiming Fair Use, How to Put Balance Back in Copyright, documentary, a very short introduction, The Daily Planet, and Communications Policy in the Public Interest. She co-coordinates the Fair Use and Free Speech project at the Center for Media and Social Impact with Professor Peter Jaszi of the Washington College of Law, creating codes of best practices with 10 communities of practice. Janet Landay is the project manager for the Fair Use Initiative at the College Art Association, where she also directs an international scholars program. Before coming to CAA, she worked as a curator and administrator at several American art museums, including the Philadelphia Museum of Art, the Museum of Fine Arts Houston, and the Detroit Institute of Arts. So, help join me in welcoming and thanking Pat and Janet for coming here to Cranbrook today.
So greetings, everybody. We're both delighted to be here, and it's a special treat for me anytime I get to come back to Detroit. I love CAA and I love Cranbrook. And what we wanted to do to start out is just get a show of hands. How many people in the audience work in a museum?
You should speak into the mic because they're recording.
Well, okay. This really is.
Or use this sign.
So a show of hands, how many people here work in libraries? I'm sorry, in museums, is what I said. Oh, terrific. Great. Libraries and archives? Lots of libraries and archives. Artists in the crowd? Terrific. Students? Great. What am I missing? Oh, publishers, editors? Great. Terrific. Well, and we are going to give an overview of the entire code of best practices, which serves all of these different sub-communities within the visual arts field. But we do want to, goodness, such pearls of wisdom are being lost here. We do want to tailor what we focus on a bit to the audience. So Pat was going to ask.
So we have first of all, I just want to give a big thank you to Greg and to Judy, who put this whole thing into motion and have gone to a lot of trouble to coordinate all of this, and we really, really appreciate it. But what we expect to do is to walk through a presentation with you in which we're going to be, in the last quarter of our presentation, going to be giving you some scenarios to kind of do an instant quiz of how you're looking at the information we gave you. So no pressure, but... and then the other thing we'd just like to know so that we could address it as we go along is, did somebody come with like a great big burning issue in their mind that they want to make sure we get on the table? Yes. Just yell it out.
I teach art history. Students would like to post their research online. This involves illustrations based on works of art from recent to 200 years ago.
Great, and of course, online is material is copyrighted online just like it is everywhere else. So the issue is the issue is similar online to any other question. So your fair use decisions can be laid right across that online question too. Yes?
So are these practices explicit where the law is ambiguous? Because
I'm sorry?
where in the new document, where are things made explicit or defined for use where the law is ambiguous?
We could, yes, we will get to that in the presentation.
My burning issue is I run a community art center, and we're concerned about some of the artwork for sale that includes sports logos. And so there was recently a center that was fined about $3,000 for the kinds of artwork it was selling because it was licensed and copyrighted. Like red.
So somebody asked and somebody paid, but which can happen. Anybody can ask. So your question is, do I really have to pay? And I think,
Or what should I not allow in our gift shop?
got it. Okay. But this is actual original artwork that's being sold.
Yes.
Okay. Any other burning questions?
I guess this goes kind of towards the first one with Blackboard, and because we're archiving our Blackboard courses, and so something like that, I was wondering about the issues there.
Great. So the issues, I think, is what some people call e-reserves, or you putting something on Blackboard, the course platform, and you have your question is, how much can you put on there legally, or is your question, can I archive it after I've legally?
Both.
Okay, great. And although you'll get some satisfaction from the visual arts code, for questions that have to do with Blackboard, you would love to have this document, which is the Association of Research Libraries Code of Best Practices and Fair Use for Academic and Research Libraries. Section 1 of this code deals explicitly with those course platforms. So, and this was so definitive and so clear and so helpful to people that when we were designing this code, people generally felt like that issue has been addressed here. So,
And Pat, you may as well give your website address because
so if you want to take a look at other people's codes, definitely take a look at cmsimpact.org. That's Center for Media and Social Impact, cmsimpact.org/fair use. And that you'll be able to access all the codes of best practices.
fair hyphen use. No?
Doesn't matter.
Oh, it doesn't matter, okay.
Okay.
It'll appear on the slides too, but
Great.
you got it.
So any other things that just you do not want to wait 45 minutes to ask? All right, well then, great, because I'm sure you're going to have some questions. So what the first thing I want to do is just tell you what we are going to do here. So the first thing we're going to do is to talk about why fair use is important in the visual arts, what difference it makes to you guys. Then we're going to give you a little basic primer on fair use, what it is. We're going to take you all the way back to step 1 in the primer of what it is. And then we're going to address the question of why a code of best practices is a good idea. And that's where your question up there will be very helpful as a trigger. We're going to specifically address what's in the CAA code, and then we're going to have fun testing our knowledge, give you a couple more resources, and then we are going to also talk with our panel. And if we have a minute before that happens, we can ask some questions.
So when CAA started this project, which is 2 years ago, and by the way, the project and this event are funded by the Andrew W. Mellon Foundation. They gave CAA a very substantial grant to take on what is a complicated project. The first thing that we did is a survey of everybody in our database at CAA. So it's not just current members, it's past members, it's people who've attended any kind of CAA event over many years. So it went out to over 12,000 people. And in that survey, the response that we got is that 70% of the respondents say that they use copyrighted material in doing their own work. We know that this included artists, art historians, educators, curators and other museum professionals, editors, librarians, archivists, and gallerists. And the most common situations were writing about art, teaching, managing museums, making art, and organizing documentation. I think that's it.
So what we discovered in that report was that in these 5 situations, when you encountered the question, can I use this without permissions, here's what happened. And here's the implications of that happening. We also found out that 1/3 of everybody in the community have either avoided doing something or have had to stop doing something because of copyright concerns. In other words, this leads to this.
And so,
And the reason why I think it's so important to take a look at that word censorship is the other thing we found out in this report is that although there are many, many gatekeepers in the lives of the creators in this world, there are lawyers, there are bosses, there are rights people, there are estates. The single biggest reason why people avoided or abandoned something was because they weren't sure themselves that they could go ahead. The great majority of those people who had abandoned or avoided had done so because they weren't sure, not because somebody else said, don't do it.
so, in fact, also on, I think, the CMSI website and the College Art Association website is this document, which was a summary of this research that Pat and her colleague Peter Yazzie led. And in addition to the survey, we did long interviews with 100 people in the visual arts, representing all the different fields that you represent. And so I just wanted to give you a very brief summary of how this breaks down. That was 1/5 of artists say they abandon work because of copyright challenges, more than 1/2 of editors and publishers, and more than 1/3 of art historians.
So basically, your field has a strong reason to understand your rights under fair use, because otherwise you're not going to get your work done in the best way it can be done. So what is fair use? In order to answer that question, you have to say what is copyright. And it's really, what I'm about to tell you is probably the single most important thing I will tell you today. There's only one reason why we have copyright law in this country. The justification for it is because the people who wrote the Constitution in which this policy is incorporated believed that it was really important to encourage people to make culture within the boundaries of the United States, which, if you'll recall, at the time was not a very impressive place. And people had alternatives for places they could go, say, write a book. And so the goal was, let's have a copyright policy that provides incentives to make to make work here. There was a big controversy among the founders about whether copyright should exist. There was a very strong feeling that the United States was being founded to fight monopolies. Monopolies by elites, monopolies by any small group of people, because monopolies stop the flow of activity. Now, that's true in antitrust law. It's true generally that this is a country that is for competition, that is for open circulation. So they did not want to especially stop ideas from circulating, because ideas circulating was their big hope of having a sustainable national identity. So their big reason to have copyright law at all was because other countries, particularly England, had it. But their other concern with copyright is this copyright giving somebody a copyright license is a monopoly. How are we going to limit that monopoly so that it will not stop the circulation of culture and the creation of new culture? So their solution was that copyright would be balanced. Yes, you would provide a perk to creators for making something here. You would also encourage new makers to use existing culture, which you would do by originally, basically the big way that you'd handle that second part of copyright law was you didn't copyright most stuff. And whatever was copyrighted was not copyrighted for very long. That, by the way, is no longer true. So the fact that copyright is so long, that it covers so many things, and that copyright extends to so many derivative uses, has suddenly made, since 1976, fair use really important. It was really a dinky part of the law. It wasn't very important before we made copyright default, before we made it really long, before we made it really strong, covering lots of stuff, which made that first part of copyright law really be unbalanced compared to the second part of it, and created a situation where copyright might be impinging on people's First Amendment rights. Remember I said you were self-censoring? If you have to go to somebody else to ask if you can say something, that person is a censor. They can choose to say yes or no. They are able to censor your speech. If the federal government permitted them to do that, the federal government has made a law that impinges on freedom of speech. And does anybody know what part of the Constitution prohibits that? Congress shall make no law. Am I beginning to sound familiar here? That would be the First Amendment. That's right. So if the first part of copyright monopoly gets so strong that copyright holders are able to censor new work, that makes copyright unconstitutional. And that's why fair use is so important now, and it's particularly important to judges, and that's the definition of fair use. So some basic things about fair use. Fair use, the way that you employ fair use is you just go ahead and use stuff. You don't ask anybody, you don't check off with a registry, you just use it. You might very well want to go tell somebody that you're using their stuff for etiquette reasons, but you would not do that for legal reasons. And the second thing is that there are not bright lines in fair use. Even lawsuits, to deal with the gentleman's question up here, do not settle the question of what you can do in a particular situation in the future, because fair use is contextual, like, by the way, all of your other expressive rights. So your First Amendment rights are not unbounded. You can't yell fire in a crowded theater. You can't libel. You can't be treasonous. You can't be obscene. Those are all limits on your freedom of speech, and they are all limits on your First Amendment rights. And the reason why people speak out loud in public without being worried that they're going to be sued into the ground is because they have a kind of understanding of where those limits of their free speech rights are. Even though their free speech rights would be contextual in every situation, every time they used it. So fair use is like that. That doesn't mean it is vague and uncertain. It means it's like every other part of your expressive rights. Some more things about fair use. You can have a project where you clear some stuff and you don't clear some stuff. You get permissions for some things, you use fair use for other things, and you don't have to be consistent. A fair use law does not depend on that level of consistency. Fair use law applies to all platforms, and it applies to all media. And my documentary filmmaker friends always say, yeah, but not music, right? Music. And finally, you can use your rights under fair use, but if you don't want to, you don't have to. What is exactly fair use under the law? Exactly is a funny word to use for fair use, because it was deliberately written into U.S. law to be very, very flexible. These are the 4 criteria that are written into the law as things you should think about. They use the word non-exclusive, meaning these might not be the only things you should think about. They also don't tell you in the law how to balance all of those things, or even really how to interpret them. That was on purpose, so that whenever somebody came up with an entirely new thing to do, they could interpret this according to the new criteria of culture. And by the way, that is how we got Google. Google's entire MO depends on fair use. And that's why the British Prime Minister is so jealous, and why he thinks that England should have fair use like the United States, because he knows that Google could never have been invented in the UK, because it could only be invented in a place that creates a wide enough berth for that second part of copyright for people to be able to fill it with new practices, like you might be doing at your own institutions. So the good news here is that really since 1990, and I'm not going to bother you with why since 1990, although feel free to read my book, but since 1990, there is a really clear way that judges typically do a fair use analysis. And we'll talk about how they do that fair use analysis. But since in the last 10 years, the Supreme Court twice has come out saying fair use is what keeps copyright constitutional. That's how important it is. It is the thing that is keeping fair use constitutional. And the regularity of this is pretty consistent. So here's the two questions that judges tend to make out of those four factors. The first thing is this a new use? So the first factor says, what's the nature of the original work? And the second one says, what's the nature of your new use? That's a question about transformativeness. Are you doing the same thing as those people were doing for their original use, or are you doing something different? Because if you're doing something different, you are actually adding to the culture. You're doing something with that existing culture, even though it's copyrighted, that's new, and that makes it generating culture, and that makes you a real friend of the law. So, by the way, not getting away with anything when you do that. You are merely sitting squarely in the center of how the law is designed. The second question is related to the first question. So you know you're reusing something. You have a different purpose than the original. How much of it are you using? Is it appropriate to that reuse? Now there's plenty of case law showing that 100% is an appropriate amount for a reuse that needs the 100%. There's also case law showing that 100% is too much in some cases given the use. Guy made a whole movie made a 16 VHS, in the old days, VHS cassette series on the life of Elvis Presley. It's a biography of Elvis Presley in video, and excerpts every single Elvis performance in a film from beginning to end. So Elvis then made this movie, Blue Hawaii. Long scenes of Elvis singing from beginning to end. And then writes on the top of the box, you'll never have to buy another Elvis movie again. The judge found that there were many, many uses in a fair use. I mean, he claimed fair use for the entire 16-part series. The judge found that there was plenty of legitimate fair use in that rather sleazeball operation. But the judge said, in some cases, this goes beyond fair use into simply reusing the original performances. Nobody ever bought an Elvis movie for the scenery. And he also used every Ed Sullivan show. And every single public performance that they could find, they stuck in there. Well, that begins to look like wall-to-wall Elvis performances that now you don't have to buy the original works for. So we have lots of case law showing that the Goldilocks principle applies. Reuse and just enough and not too much and not too little. And not too much and not too little, by the way, is not one of those things where if you guessed wrong by a hair, you'd be in trouble. What the judges say is reasonable, good faith, best attempt. Okay, here's the kicker. When judges make that call, were you transformative? Did you use the appropriate amount? Behind that question is, what exactly do you do? What field are you in, and how is this creating new culture? We need to know something about your context in order to understand how to evaluate this. So functionally and practically, even though this is not in the law, it's actually really important to any case law, and therefore to any kind of decision made by anybody who has to take a risk. It's really important to say, how does this tie back to the field's creation of culture? Am I still going on?
You are still going.
Okay. So I have just given you some great news. I've given you basic logic. I've given you the basic reasoning. I've shown you that since 1990, judges are overwhelmingly falling over themselves to support fair use. So how come so many people are scared of fair use? So you have several issues that were flagged in our study. One is, well, I'm worried about legal trouble, but actually, real life, in your survey, you told us that that was probably not number one in your concerns, even though it lurks in the back of people's minds. Another real concern of yours was, right now, everybody clears everything. And if I might look like an outlier in my field, and I might ruin my reputation. I might look like one of the crazy ones. And if somebody saw that I wasn't getting permission, does this mean that I would suffer some reputational problems? So those are also significant issues. Now, what people were talking about was risk. So I want to just spend a minute on risk. There are real risks, there always are real risks to using your rights. This is a free country. People can not only complain, they can sue you. It is entirely possible that someday you will run into a crazy person who will just decide that they can sue you. Now, they might have trouble bringing their lawsuit because it might not have merit, but nothing is going to stop them from trying. So in the real world, it is always possible, however remote, that somebody could sue you. So you would always be taking a certain risk in using any of your rights. And that is true of any free speech right. And if you want to be safe, absolutely safe, what you really have to ask yourself is, does absolute safety affect the second part? If I'm absolutely safe, can I still do my work? Now, what you told us in your study is, no, you can't, because a third of you stopped doing stuff or decided not even to think about doing stuff because you faced copyright problems. So this risk is actually, the second risk is very, very big. So you're always trying to balance those two. No, nobody likes to get into any trouble. Well, some people, but probably not the people here. But do you want to? Do you also want to be so safe that you don't even get your work done? That is where best practices codes end up helping people enormously. Now, am I?
I think, well, let's see what the next part.
No, okay. So, how do codes of best practices differ from those things that do not help you make a decision? Things that don't help you make a decision are the ones that say you can use 400 words, you can use 30 seconds, you can use 10%, you can, if you alter it 7 times, it's fine. All of those are completely bogus. Although we hear them a lot, they are folklore. And while they might be fine as a rule of thumb in a highly specific circumstance, since fair use is contextual, they're really not going to help you make a decision in most circumstances, and they especially will not help you in the law. Another thing that won't help you is, well, it's non-commercial, because non-commercial might strengthen an argument, but it's not an argument for fair use. It's educational. Again, it's nice if it's educational, but that doesn't necessarily make it fair use. So what this is, well, all of these codes of best practices have similarities. They're all created around a set of situations that are the most common situations for a field to encounter the need for fair use. And within those situations, people specify what kinds of things do we think about as limiting features to that. So no, there's no bright line, and there shouldn't be a bright line for the same reason that all your other expressive rights should not have bright lines. If on obscenity, they made a long list of body parts that you should never say out loud. All those people who do reproductive rights work with teenagers would really be screwed. And so you don't want arbitrary limits. You don't want bright lines. What you would like to know, however, is what do people think is the best way to behave in this circumstance in the most common situations? And then once you understand that, you will be much better armed to deal with the wide world of fair use beyond those most common situations in which there isn't a clear best practice. They are all organized and created by people who do the professional creative work, not the people that they may answer to and not the people who sell or buy from them. So these never involve checking in with the lawyers, they never involve working with the archives, they never involve checking with ARS and VAGA, making sure that the Picasso estate is happy with my idea of why I need fair use. Because frankly, the Picasso estate has nothing to say about your fair use rights by definition. They also would be uninterested in clarifying them for you. Because their whole business is charging people. That's their business. It's a fine business to be in. But it's, they're not in the business of creating new culture. They're in the business of just selling those pictures. So there's no need, there's no negotiation in these best practices. The question is also, who are they written for? Well, the first people they're written for is people who do this work. In this work, we think that the best practices are this. It so happens that they are very handy for those next three categories. If you believe, as the professional if say you're a curator of a museum, you believe that the best practice would be employing fair use in this situation, to do the curation right, you're in a very strong position to take this code to, say, your general counsel or your legal team, and to say, in this case, we believe we have a strong right here. Even though it might not be what we've done in the past, check out what the field thinks of. You know, a lot of the gatekeepers you work with are concerned to make sure that you're safe and that you're going to be able to survive any kind of attack to do the next thing. That's their job. But what they also want to do is to make sure that you are doing the thing that you came to do. So if you have a talk saying, I believe that we can do our job to the highest standards of this field if we employ this right, they very well might be interested. Also, if somebody sends you one of those cease and desist letters, or a nastygram as we call them, this code of best practices is really helpful to you in knowing whether to answer that or how to answer it. And if in answering it you say, you know, you really might want to take a look at this code of best practices, that's also a very helpful point. And of course, in the end, it would be great if if judges used it as well. So you guys are not the first. As I pointed out, there's been 10 years of work. Documentary filmmakers, communication scholars, poets, librarians, and many other people have made codes of best practices. What difference has it made? It's been incredible, actually. Doc filmmakers have had their code out the longest. They have seen, we just did a study showing changes in the field in 10 years. 10 years ago, documentary filmmakers routinely cleared everything in their films, even though their films are completely laced from start to finish with third-party material. And now, the great majority of filmmakers employ fair use routinely. Insurers did not insure against, errors and omissions insurers did not insure against any fair use claims. They would insure you for everything else, but not that. Now they routinely accept fair use claims. Broadcasters, it was an automatic no if you had a fair use claim 10 years ago. Now, nobody has said, 95% of the respondents in this survey said they had never experienced a problem with a broadcaster. What's happened with librarians, they've been able, among other things, to post collections online for which they do not hold copyright, and be able to harvest information from crowdsource metadata to learn more about where did these pictures come from, for instance. And they've been able to do something they've wanted to do for a long time, which is to take old or decaying technology, particularly VHS tapes, and without having to enact a different part, enable a different part of copyright law, which is Section 108. If anybody as a librarian here, you're probably familiar with Section 108 preservation. Without doing that, what they want to be able to do, if somebody needs a DVD and it isn't on the market, to be able to make a copy of the DVD without, the VHS to DVD without running some serious risk. The code helped them do that. It's now routine. Scholars have been able to go to publishers and get new work published with the proper illustrations to make their argument. Archivists have been able to put up work online. 2 examples. Power to the People is a recent book published by University of Chicago Press. It involves a lot of ephemera. It's 1970s ephemera, radical press stuff. Overwhelmingly, that book, almost all the images have been fairly used. And University of Chicago Press had no trouble with it. Another example that I think would be great for the museum community to know about, we worked with dance archivists to create a code for them. The dance archivists, Jacob's Pillow is a big dance company, and they have a wonderful archive. It's full of old stuff that mostly inadequately records choreography. What they've done with this interactive exhibit is to, and you can go online here, just Google those words at the upper left. You can see that you can choose to enter their exhibit in one of these 3 categories: artist, genre, or area. You can watch video of choreography. You can get a visual, you can get a description of that choreography and the key people. You can click on the artist and see more work by that artist. You can organize this by era. All of this material is copyrighted to other people. The archive had no copyright in any of it, and all of it is excerpted appropriate to this exhibit, this online exhibit, which is not intended to show you an entire dance. It is intended to give you a flavor of what's this dance style like.
So, this is a big introduction to the topic and the process that Pat and Peter have gone through in developing other codes. So, to reiterate what CAA did, we did the very smart thing of hiring Peter and Pat to do this for us. But the first thing they said is, it's not something we do, it's something you do that we facilitate. So, as I said, we started with a survey. Actually, what we started with was developing a task force made up of CAA members, very carefully selecting people who represent the different sub-communities. And by the way, did I ask if there are art historians in the group? Great, okay. Big part of CAA. We developed a survey instrument, which took a while even to think about what kinds of questions we wanted to ask. We tested it. We had a preliminary phase of testing many things, and then did the survey that I mentioned, followed by, it took about 8 months to do 100 surveys. 100 telephone interviews, and Peter and Pat conducted each of those. That asked similar questions about how people used copyrighted materials, what kind of problems they encountered, and how fair use might help them, and what were their current understanding of their fair use rights. Together, that information led to the publication of the issues report, this one, which, as I say, you can find on our website. Working with that as the basis of the material, the next several months were spent in organizing 10 discussion groups. These were 2 in 5 cities around, 2 each in 5 cities around the country. And these were comprised of people, again, representing artists, editors, museum people, art historians, but using the information that had been gathered as a basis for discussion, saying, okay, we now understand a lot of the common understandings about fair use, a lot of the common challenges, and what we want to do is find areas of consensus. Where do people already agree? Where do people have some disagreement? And see if we can tease out from that a set of principles that, as a community of practice, we can rely on. So the Fair Use Code actually represents a summation of, or a gathering of principles based on many, many conversations with people representing the same fields all of you are in. Some of you may have been in our discussions, although I don't think so, but we did have people from Detroit. Peter and Pat wrote the first draft of this document, which then went through many readings by our task force, by CAA's Intellectual Property Committee, by our Professional Practices Committee, and finally by a group of lawyers. So we created a legal advisory committee that vetted everything in here very carefully, so that not only are these consensus principles, but we know that experts in this field agree that they fall within legal use of copyright and fair use. And what comes next? Who participated? Okay, this is where I just went through that, so the next one. And culling from the discussions and from all that we had learned thus far, we were able to identify 5 areas around which to organize the information. So the first part of the code addresses issues where fair use can be invoked in writing about art. The second is in teaching. The third is making new art. The fourth is all kinds of museum uses. And the fifth is archives, especially online. And so if you've read the code, or when you read the code, you'll see that those are the organizing categories for the work.
So for each of these 5 categories that we mentioned, there's a description of the activity in the field that goes on, whether it's under fair use or not. There's a principle explaining that fair use applies in this if, and then there's the limitations. And the limitations are, in a way, the definition, really, because what they tell you is when people thought, beyond this, we don't think we have a professional claim to that material beyond this point. So those limitations are kind of that's where the rubber hits the road. That's when you know. Okay, so now we've given you the basics. You are all officially fair use experts. And now we're going to test our knowledge. So can I ask you to just read that for a sec? This is a fairly common problem. Does anybody need more time reading? Okay, this is a very common situation. And in fact, in most journals, the default is always like, yeah, you clear everything. In other words, you take all the risk, don't bring the risk to us. So, because we will share your risk. So you make sure that everything is all hunky-dory there. But so your first question would be, do I need to get permission under the law for this particular use, which is you're writing an article comparing these 2 painters, and you've got pictures of the 2 painters. So you've got like 5 of one, 4 of another. And you've discussed these painters. There's some caption under them or some description in the text that would justify your use of one picture rather than another of their work, other than this is the one you could get hold of. You're going to publish this in a place where they will accept the quality level you have. So you don't have to go back to an original source. One of the things about fair use is You can only use it if you have access to the material. If the material you want is in the hands of somebody who is guarding it and you need exactly what they have, you will do whatever they say. And waving your fair use rights around will not impress them. So for this, we're assuming you actually have access to copies of the work you want to do. Okay. So how many people think that legally you have the right to employ fair use here? How many people think that under the law you do not have the right to employ fair use? The people who did not, you do? No.
Yeah, a few people raise their hand.
Yes, who doesn't think that it's legal to do that? And why?
Well, in my job, I have resolutions for things like that all the time.
So your answer is, right now, that's not what I do. You would be right. Right now, that's not what anybody's doing, really. Every once in a while, you do have, there are journals that accept fair use. It seems like it's still fairly new in the visual arts.
What is your job, by the way?
I'm a visual resources librarian.
So you're right now being required to get permissions. So this code is providing you with legal reasons why it is going to be possible under the law for you to do that. So it's not the law that's holding you back. What's holding you back is custom and the fact that people around you and possibly above you in the hierarchy of your institution have made a risk assessment saying that's too risky for us. The code actually changes risk levels. That's why insurers didn't have a problem insuring documentary filmmakers. Insurers really could care less what kind of art they're insuring. They are not interested in enabling filmmakers to do wonderful work. The only thing they're interested in is, will they suffer more risk? So the insurers are a very clear indicator of, do these things lower risk? Yes, they do. So now you have a new conversation you could have. But who else doesn't believe it's legal?
I'm not arguing that it's legal. I think that the conversation is that the journal, regardless of how we feel and what we present to them, the journals won't take it.
So this is actually hugely important. That's the second question. But let me just make sure, is there anybody who does not think that that is a fair use eligible situation? Yeah.
Do you really not have to factor in whether or not the journal is free or they?
No, you don't.
The journal?
You don't. All of fair use law is done about products in the marketplace. Otherwise, they wouldn't sue because there's no money. So it's all about products that are commercial. That's not important. It's a nice thing maybe if everything else is, if the transformative reason is clear and it's free and it's educational. Well, those are like cherry on top kind of things. Okay, anybody else who has doubts? So yes.
Can I just complicate it a little bit? You talked a little bit about where the image came from. It seems like that has a lot to do with where the image that you had came from.
So do you mean international, where the image came from? Do you mean national or international?
No, I mean just what was the source of the...
So if you got an image from a source where you had to make an agreement with the source to get it, which is what you're going to do if you go to an estate and say, I'd like that image, you're going to sign a contract with those people. And the contract will override your fair use rights. And this is why we say you have to have independent access to this material in order to employ fair use. This is not a magic wand that you can wave over all your permissions problems, because you may very well have many kinds of things that you need to get access from somebody who will make you sign a contract to get access to it. That's something that the lawyers call sole source. They're the only people, they can do what they want to. But the national, international, on the web, out of your back pocket, it doesn't really matter where it came from. Fair use would apply no matter what. If you stole it from somewhere and you went into a a lawsuit about it, the fact that you stole it might make judges regard you as less of a nice person in the decision, and that would be important.
Can you hone in a little bit on transformative versus derivative?
So it is derivative would be you're making something from an original that is close enough or derived from it so clearly that that the monopoly rights carry over. Like somebody wrote a novel and now somebody's writing a play and it's the same story, same characters, blah, blah, blah. That is going to be a clear derivative use. The question is, are you doing something different with it? The people who wrote the play are using the novel as the basis for their play, and they are only doing what the novel did in terms of telling the story. There's just a lawsuit that was settled called, did anybody follow this? Three's Company and 3C? So Three's Company, everybody remember Three's Company? Television sitcom? Okay. So 3C is a rather grim New York play about these people who are exactly the characters in Three's Company. Only all of their conversations kind of expose the racist, sexist, homophobic undercurrents of the culture in the time. So Three's Company says, the company who owns Three's Company says, that play is based on Three's Company. It's a derivative work. And the judge says, I don't think so. Have you seen the play? The play is clearly making a different point, and it serves a different purpose. And it is using Three's Company with a real reason to use Three's Company. The fact that it was Three's Company means Three's Company, you know what Three's Company was. It was like froth entertainment for 8 o'clock at night, oriented to 20s and 30-somethings. And therefore, the playwright has chosen this work as exemplary of the culture at the time. And it's important that it was Three's Company, but he's done something transformative with it. He's not simply trying to produce a play's version of Three's Company for the purpose of Three's Company. Does that help? No. And by the way, no bright lines. You're asking yourself that question, and you're asking yourself that question not in terms of, could I get away with an argument that if I twisted it this way and that way? You'd really want to be thinking more about like a conversation that was like a conversation something you could say, without being Jesuitical about it. Like at Thanksgiving dinner to somebody who didn't follow your field. They could be plausible to somebody who knows nothing about your field. The reason we did it was this. And this actually goes back to a really important point. Storytelling is really actually important in fair use. Knowing what you're doing makes a really big difference. If what you're saying is, I'm doing this because I think I can get away with it. I think the guidelines would let me. That's actually not a reason. And if you say, I'm an artist, I just do it because my inner creative force says I have to. What happens if you bring that into court is what happened to Jeff Koons the first time he got sued, which is the judge says, he won't talk to me. I have no idea why he did this stupid thing. The whole thing does not even look like art to me. I do not know. But I'm just saying he used the other guy's stuff. And the second time Jeff Koons gets sued, he's like, got better lawyering, I guess. Or maybe he's grown up a little, hard to imagine. But he says, actually, here's what I was trying to do with that. And he's got a story to tell that says something about reuse. Okay, and one more question before we go to the next example.
I had a question about the comment you made about it's all about products for sale in the marketplace. Why is a journal about art that's being sold for dollars not a product for sale? What's the difference?
I think I confused you with this this term. What I'm talking about is we're all operating in a marketplace, even when it's non-commercial. I mean, people are putting up all kinds of, teenagers are putting up YouTube videos that are done in their in their bedrooms, and it has no commercial intent whatsoever, but it's up on YouTube, which, by the way, is a commercial site. So we're just never going to get out of that. So the question is the original market versus the new. Because the people who created that stuff originally, in their copyright monopoly, they have a right to a market for that work for their fixed amount of time, which now happens to be close to forever. But they have a right to control that market for their work. They don't have a right to control all markets in all uses forever. The copyright law is very clear. So they're not in the writing analytical work about these two artists' business. So that's the difference between the original market and what you're now doing. I'm sorry I confused you. And that must be a really important question. Okay.
Any idea how you get hold of those decent images without jumping through? A lawyer once told me that if the museum was carrying the work across the street and you happened to be there with your camera and snapped a photo, you could use that photo. But that situation doesn't happen.
You're right. But there are a lot of images, particularly on the web, of work. Now, whether those are going to be high quality enough for you, that I don't know. But you could also take pictures from a book, and I understood from some of these conversations I had with people that that it's possible to strip off filters from that picture with digital technology. I don't understand this stuff.
It's a question that is going to bother us for a long time, and especially with the artists' estates, they hold very closely to their best quality images. But over time, technology should make that easier because there are so many images online, some of which are probably good enough quality for many uses. Now, the highest quality for the highest quality needs, probably we're stuck with going to those artist estates for quite a while. So I too, when we started this project, thought that this might help us get around that obstacle. It doesn't.
However, what we did hear from several people who edit online journals is that they are routinely using web-based images and they are working just fine for their purposes. So somebody's going yes. Yeah, you may have reasons why you need to have a sole source image, but a lot of people are having a lot of uses where they don't need that. One more question, one more little test. We're not going to run through all 5 because we don't have time with you today, but one more.
Maybe we should do a museum or
library. How about 3? My team is mounting an exhibit.
Yeah, and why don't we look at this one? My team is mounting an exhibition on art from 21st century protest movements with a web component and an interactive online catalog. Some of this art is born digital, some is ephemeral, and some of it was created anonymously. I've got access to much of the work already, but do I need also to seek permissions? So actually what I'd like to do is, do you all have the booklet, the code in your hands? If we go to page 12. And we'll do this as quickly as possible. The principle is that we can use fair use. We can invoke fair use when we are using them in furtherance of our core missions, subject to the following limitations. So we know the mission of the museum certainly is to share, exhibit art, and visual material for the edification and pleasure of its visitors. So what are the limitations? When copyrighted works are used in connection with physical or virtual exhibitions, the use should be justified by the curatorial objective, and the user should be prepared to articulate that justification. So that's the same thing. I need to be able to explain why I wanted to use any of these images. The amount of work should be appropriate to what is needed, and the level of fidelity should be appropriate to the analytic or educational purpose. So again, especially in a subject like this, it may be that there things that can be shown or reproduced that aren't of the highest quality. They may never have been printed in a high quality, as a matter of fact. Downloadable images made available online should be suitable in size for full screen projection or display on a personal computer, but not larger. Now, this has come up, any of you who know the principle of AAMD about thumbnail images. This code takes that certainly one big step forward. It's saying it doesn't have to necessarily be thumbnail. It can be bigger than that if it's a justifiable reason. However, we will agree that we're not going to expect to be able to broadcast this in a movie theater, because then we may be stepping on somebody's rights for use of that image. Okay, and another thing that's going on in museums is the close looking, where you can get closer to a work of art online. So here it says, when images are presented for close looking through large or high resolution images, downloading should not be facilitated unless a special justification is present. So we make it hard for somebody to use a pirated copy from this project. Images provided to the public should be accompanied by attribution of the original work as is customary in the field, to the extent possible. And by the way, this is a limitation in every single one of the 5 uses. So for that first academic article example, we of course assume there'll be attribution to every image. It's true, it's customary in museums. Well, according to the principles laid out here by your peers, it should be customary in any use of copyrighted material that a full, as complete an attribution as possible is given, including artists who may not want to write on the artwork what the source of their image is, but they should have it available. They should know what it is. Images provided to the public should be accompanied by, I just did that one. Images and other documentation of museum collections should be associated with all appropriate and reasonably available metadata. You want to explain that one a little? The metadata.
So this is actually using metadata as a fancy word to say, make sure that people understand what it is. The kind of description you would put into, and put into the
Label or
anything. Yeah.
catalog, et cetera. And then the final one is images and documentations of museum collections should honor institutional policies designed to protect non-copyrighted interests of third parties, including the privacy of individuals and the cultural sensitivities of communities. So there is a judgment call there to be made, but if considered and defended by the people using it, that is a limitation that you can defend on your use of fair use in using that copyrighted material. So, in voting, everybody, does the museum need legally to get permission for the online exhibition of this work? Yes? No. You're a smart audience.
So, with example 1 and example 3, which we went through, in each case, the real answer would depend on your answer to all of those limiting clauses. Because if you weren't matching up in some way with one of those limiting clauses, you'd really want to get in conformity with that clause or decide that you shouldn't be fair using because your use exceeded fair use. So these limitations are absolutely critical. There's never going to be a thumbs up, yes, that's fine. All you can say from this is it's fair use eligible. Once it's fair use eligible, then you'd be going to those limitations and saying, what about this? Am I doing that? Am I doing the other thing? Okay, I'm comfortable that this is the best practice in the field. Could some uses that did not conform to all of those limitations also be fair use? Sure. They're just not in the warm, comfy couch safety zone that you will be in if you stay in the limitations. Because there's a lot of fair use beyond this little safe harbor area. But you know that you are we're in a very low-risk situation when you stay within the safe harbor situation. We are going to scamper on. We only have a couple minutes left. So
Right, so what can you do? And this is really important. One reason CAA wants to go around the country talking to you all is to tell all of you about the code, but also to encourage you to do the following. Use the code. Even if you are in an institution where you're going to come up against a gatekeeper, a lawyer who says, no, you can't, start talking about it. Show the lawyer the code. Say, this is something for us to be thinking about. This is something that's changing in our field. And some of us who work here actually think we should be able to invoke fair use here. We recognize the institution hasn't changed its policy, but we should be thinking about it and talking about it. Tell a colleague. All of you work, most of you anyway, work in institutions with other people. Make sure they've seen the code, tell them about it, say why it's interesting and important to the work that each of you do.
we brought extra copies.
That's
Take
right.
them home.
That's right, exactly. Tell a student, those of you who teach, we, in our survey work, found that some people who teach actually bring up this subject, especially people who teach studio art. It comes up whenever this topic of appropriation comes up, for example, and they make it a part of their curriculum. But in many, many cases, the subject of copyright use doesn't come up. Well, make it part of your curriculum, even if it's 15 minutes in the course of the semester. Tell a publisher, when you're going to publish that article and they say you have to go get permissions for all of these things, say, well, if that's the only way I can get published, I guess I will, but I want you to know we have this fair use code, and it's telling us otherwise.
And by the way, communication scholars have done that again and again, and it is actually working.
And it is changing in our field as well. And there are, I mean, the two examples that are at the top of my tongue are the University of Chicago relies on fair use for many of its publications now and has not had any problems. Not all their publications, but many. And there's a women's art journal published out of Rutgers. They've relied on fair use from their inception. They just made it a policy, and they've never had a problem.
Also Cabinet.
Oh, and Cabinet, that's right.
So I'm going to spend 1 minute showing you the website, because both College Art Association and my center have showcased, they are mirror sites showcasing the same material. And so I just want to take us as soon as this.
Oh, and there's a really complete set of questions and answers of frequently asked questions on these websites, which are very useful.
Okay, not sure how to get back to the website. It's not showing up here. Oh, wait a second. There it is. Okay, so I'm just going to show you the center site, and the questions. You can see, get the code here. You can get a lovely little infographic. I must say that it does very well on Twitter. You can have a video, which is very helpful with students. It's a 7-minute film. You can take a little quiz yourself about several common situations in fair use. See what you be the judge, and many other things. But what we want to show you is fair use, because we're not fair use FAQ, because we don't have time to answer many questions today. But in fact, many of the questions we encounter are questions like questions other people have already asked. So we have a fairly extensive list here of questions that you can see. And they deal with all the areas, the 5 areas of the code. One of the things we want to know is, can you ask a question that is not on this list? Because if you can, probably somebody else wants to ask that same question, and we could write it into the frequently asked questions. So Janet is ready to hear your questions.
Right. Yes, and write me. All those same information is on the CAA website, and write me, although we're giving the New York office email for that time when I may not be there to answer your questions. But we really do, we are getting email queries, and we answer every one of them. So if you have a question, please write to us.
Thank you.
And that's the end of this part of the program. Thank you.
Thank you so much, Pat and Janet. That was wonderful, very informative. Okay, at this point, we'd like to invite our 5 panelists up to the table. And while you're coming up, I'm going to turn on your microphones. Okay, as Greg mentioned, we've invited 5 local arts professionals to join us today to offer their thoughts and comments about the code, about copyright, fair use in general. And we've invited them relating to the 5 situations that are outlined in the code. So let me make sure I get everybody in order here. At the far left, we have Jane Hoehner, who's the director of Wayne State University Press. Next to her is Diana Ing, who's assistant professor of art history at the University of Michigan-Dearborn. Next is Mark Newport, artist in residence and head of the fiber department here at Cranbrook Academy of Art, one of our own. Next to Mark, we have Dina Mean, who's manager of the archives and library at the Benson Ford Research Center at the Henry Ford. And Terry Segal, associate registrar at Detroit Institute of Arts. So, Jane, would you like to begin?
Sure. Do I need the microphone?
Please.
Yes. Thank you. Okay, so I'm going to take this off. Hi, and thanks for having me here. I am going to speak really specifically just about a very small piece that ties in with this code. As a little bit of a background to that, in the context, Wayne State University Press is clearly down at Wayne State University in Detroit, and one of the pretty big pieces of our publishing program is a film and media studies list, and that's where we really had the most issue with rights and permissions, at least in relation to this document and this entire presentation. There was, and I caught a brief glimpse of it during the slides that it showed other codes. There's an organization called SCMS, which is Society of Cinema and Media Studies, and they did come up with a set of guidelines a number of years back that they tend to update on a pretty regular basis. They're not nearly as succinct or as easy to digest or get through. It's a much, much longer document, and it's somewhat helpful. Kind of came about based on people in that community, communication and, again, media studies, saying we need something for publication, both from the side of scholars doing the publishing and then from the publisher's side. So we tend to, our practice is pretty much to seek permission for everything that we put on covers of our books and not so much for the interior. So especially when it comes to film and media studies. So for film stills, publicity stills that are tying directly into critical analysis in the book, we do not worry about that for the most part. I mean, if you've ever seen a screen capture, they're not the highest quality. It is just that. It's a snapshot of a moment in the moving film, and it really is in scholarship there to illustrate a point. So we've not had difficulties there. We have had difficulties with some images on covers, and so we do defer and to err on the side of caution. Also, much encouraged, or I should say, we are not encouraged to get into risky situations with general counsel at Wayne State. So they're sympathetic and they get our situation and they get this entire premise. However, if push comes to shove, they will, we're the ones who have to desist. They will not get into any sort of litigation on our behalf. So that means we have to play, I guess cautiously, which we do. Having this code, I'm really glad to have this code, to have something else in addition to the SCMS document, and just something that is more general that we can, again, sort of refer to. And we plan to, I've already sent it to my pals over at General Counsel, and they are actually that. They're great people who are supportive, but they're lawyers. So they've seen it and they think it's a great thing and something to have to refer to again. But this is, and fair use is in itself so meant to be flexible, and in this whole, everything is on a case-by-case basis, that there can't ever be something that's more binding, that's more definitive. I know there's so many questions like, well, in this particular situation, and I have them too. I have a list of questions for the panelists, actually, the presentation, because things strike me as, well, if I could get the answer for this particular question, and it's not that easy, unfortunately. So that's sort of our story, and I'll pass it down to my colleague. Okay, thank you.
Maybe before you do
Oh,
that,
sure.
I'd be curious
Yes.
to ask comments on, they've already told us that they're not lawyers sitting up here, their role is not to say yes or no, but under the policy that has been written, should Jane be protesting a little bit harder with legal counsel at Wayne about the use of an image on the cover of a book versus the interior of it?
Oh, never mind. So I think that you have great counsel. I also love your line. My students read Documenting the Documentary every semester. But Wayne State has indeed been really a great model for common sense, fair use in the visual arts. And Peter Yassi, who I work with, that was one of his very first projects, to create a code of best practices. So after I got involved, they got shorter. But I think that that's a smart thing to do, to be very cautious about covers, because covers function as advertisements. And it's possible to create a really good fair use case for reuse in a cover where you've designed something, you've used several elements, you've recombined it, but you are on thinner ice than you are with the actual work of scholarship inside the book. And I can see why the lawyers would say, this is basically, advertising has a lower, it has less right to First Amendment law than speech generally. Commercial speech does. So, and by commercial, we don't mean somebody selling it. So, since it is kind of in the category of advertising, I think that your lawyers are kind of helping you. Although I think it would be possible to create a fair use argument for some kinds of uses.
Okay, so I think in a way my response from the perspective of teaching the arts, of teaching the arts is probably easiest to give. Is it me that's like causing it to? It has become increasingly important for teaching art historians to provide students with remote access to the artworks presented in face-to-face class time. Speaking from my own experience of being trained as a student and as a young instructor in the age of film slides, and then transitioning to exclusive use of digital images, this technological shift made me quite susceptible to the culture of permissions that the code was designed to address. At different times and at different institutions and different departments that I've taught in, there have been uncertainties as to how images can be used in a way that serves both teaching purposes and also the rights of the copy holders. And those uncertainties have probably resulted in making life a little bit more difficult than it should have been. And I was quite pleased to see that the best practices laid out in the CAA code are already really the ones that my colleagues at Dearborn follow. We are as careful as we can be, given the realities of teaching prep, to use images of artworks that have been added to our VRC from required textbooks, from subscription-based services like ArtStore or others that explicitly allow for fair use or teaching use of images, and from museum websites that also explicitly allow for fair use of downloaded images. In addition, we either create for our students a portfolio of images that is housed in our university's digital collections and accessible only to members of the university community, or we insert images into PowerPoint galleries that have proper labeling and didactic information, and then convert those PowerPoint presentations to PDFs and then upload them to course management systems. Sites like Blackboard or Canvas, which is the one that we use at Dearborn, are really helpful in ensuring that the galleries of images that we put online remain within the limitations for fair use as set forth in the code, because they're only accessible to enrolled students. By posting the images in PDF form, also, we can make sure that the artworks are available for study, but not in a larger size or in higher resolution than is necessary. And we can also unpublish those study galleries at any time. I think the code's emphasis on the transformative use of images in our pedagogical intention, in the incorporation of images into study galleries, sometimes with additional commentary or superimposed diagramming, is really at the core of how art historians can have flexibility and latitude and maximize the effectiveness of their teaching and student learning support within the boundaries of fair use. I might also add that many colleagues in English are also increasingly teaching and studying the intersections between literary and visual cultures in various periods, and so this code would be useful to them as well. The code also has raised some issues that art historians should be, and I'm speaking really for myself, should be more mindful of when gathering teaching images. And I think, many of us have had to pull an image or two from the internet via Google searches or Flickr at the last minute when a specific view or a detail of an artwork is not available in our database or in our institution's collections. Often, because we are in a hurry, we don't check to see what Creative Commons licensing the photographer who uploaded those images may have applied to their work. And the reference in the code to Creative Commons licensing is a really useful reminder that we should be careful and educate ourselves on the different rules for attribution, share alike, or total assertions of copyright, and to adjust our usage of such images for teaching accordingly, and to include proper attribution when necessary, and so on. As more and more creators of images, people who are taking photos in museums or on, vacations, are putting them up online, and there is this kind of increasingly common idea of this universal repository of images on the web is kind of taking hold. I think it is still important to have more guidelines or more examples, such as, some of the directions provided in the code, just to, help us deal with the ambivalence that, we probably all feel when we are taking advantage of these resources. In addition, our students will often look for images online to illustrate their research papers or class presentations. We want to encourage them to use the databases and collections that are part of our institutional resources, but we should also educate them about fair use. So the resources that have already been highlighted, or a copy of the code that we as instructors can adapt for students, would be really helpful. I mean, these students maybe go on to become art historians, to teach art history, or to produce analytical writing, but they might also be creating their own blogs, and they need to know about fair use of images. As to the question posed by the flyer for this event, when can I use a photo I took in a museum for teaching, and can such an image be posted on the course management websites? The code also provides some direction, although, as a somewhat sort of neurotic art historian, I would always love to have more sort of instruction. There seems to be, a copyright-free status associated with photos of two-dimensional works such as paintings, but sculpture, architecture, and performance are obviously also major parts of the art historical curricula. How can we teach our research, in addition, in accordance with fair use, when our research includes sculptures or architecture that are in public domain but are under the control of foreign museums or archaeological superintendencies, or involve video footage of performance art? I think careful reading of the code suggests that more often than not, fair use would still obtain in pedagogical situations within the limitations that were defined. But nevertheless, there's still a lot of room for interpretation and clarification, and I think, that's just the nature of things. So anyway, that's my kind of take on it.
before Mark takes the stage, I mean, Pat, if you would be willing to just offer brief commentary on any of these, I mean, is she being overly cautious in some areas, or is she, right on?
I am restraining myself from giving Diana a hug. I just think it's exciting to see somebody being responsibly employing fair use already in terms of creating these pedagogical materials, and the fact that she is now going to be teaching the students what is responsible copyright practice is really important. Most of your students have been educated their entire lives to a fear of fair use. They go through this rebellious period, sometime like late middle school, where yes, I can just rip everything off. And that sort of stops sometime about the time they're 25 and realize they want to make work. And in the meantime, they have divided the world into, I can license it and it's fine, or any kind of unlicensed use is piracy. And that's a very poisonous way to think. It's especially poisonous for artists because it does not let them know what their actual rights to create on the back of existing culture are, and why the law does not just permit that, but encourages that. The issue that Diana pointed to, which I think is so important, which is that sometimes you have permissions rights from photography of three-dimensional stuff, not two-dimensional, because that's actually settled in law. If all a photograph did was to capture the image and there's no added creative value here, that's not copyrightable. But if they took it in 3 dimensions, that legal decision does not apply because it wasn't litigated around 3 dimensions. So you still got these questions of, do I need to pay permissions? Well, if that's your only source for that Central American pot, yes, you do, because it's sole source. But if you were able to get an independent version of that, no, you don't owe those people anything.
Can I add something on that? Just to that last point, the Society of Architectural Historians, which in fact I'm pleased to report just last week endorsed the CAA code. So for one, they're absolutely intending to rely on fair use according to these guidelines. But they're doing something interesting that I think is in the same spirit, which is they have an enormous archive of architectural images, and they have made that open so that anybody who wants to contribute an image to that archive can, and those are all copyright-free images. It used to be that all their images were from museums, archives, archaeological sites, and they said, for teaching, this is crazy. So,
but they're not copyright-free, right? They are merely being made available under fair use. Because
that's right.
Copyright.
Forgive me.
You
Yes.
take a picture of the Sphinx, it's copyrighted to you, default, for 70 years after your death. So that's why you want fair use.
Okay. So, I'm the artist on the panel. Either the problem child or the the reason we're here, right? So I'm an artist who over the past 20 years, maybe 30, has used copyright material in my work. Up until 2005, I did so with little knowledge about the laws that govern fair use, but with the belief that I could use this material, and now I'm quoting Patricia, because I am an artist. Thank you for that. By the way, that was great. My education in studio and art history classes made it clear that art builds upon and works in reaction to the art and culture that preceded it and that it's surrounded by. So it was clear, and still is to me, that cultural production, be it the venerated holdings of the museum or the crass throwaway comic strip that I adore so much, are inspiration and source material for artists. My use of copyrighted material started simply and in a vein that fit the times. In the mid-1980s, I used images from magazines, think appropriation, copied them out of the magazines, wove them into tapestries. As my exploration of gender and media matured, I hope, the sources of the imagery became clearer, and the line between inspiration and comment more complicated. In 2003, I started a series of work that was hand-knit recreations of quote-unquote real superhero costumes, think Batman, and costumes for my own heroes. Those works received some attention, including grants and then my first museum shows. And in 2005, two things happened that were relevant to today's topic. First, my solo show at a museum, not this one, just to make sure Greg's not freaking out, was threatened because an employee of the museum, not one of the curators, went to the University General Counsel that housed the museum and said, I think we have problems because this guy steals copyrighted material and we could be in trouble. The curator called me and told me we might have to cancel your show. The next thing that happened is I received a letter from a very large corporation you might have heard of called DC Comics. They asked me if I would like to purchase licensing agreements to use their cartoon character Batman in my work. Batman is one of my favorite characters. Unfortunately, at first, I didn't know what to do about the letter. I'd never received a letter from a lawyer. I was like, what the heck do I do? But I was really lucky. I was working with a group called Creative Capital, and they put me together with a lawyer that deals with fair use and copyright. And she said, you don't have to do anything. They know they're fishing. You're working completely within the guidelines set by fair use, and you should just continue with your work. The museum show, to get back to that, did eventually go on, but the general counsel at the university deemed it appropriate that I sign a waiver releasing the university from any kind of liability for my egregious use of copyrighted material. As an artist, I believe that I have limited ownership of my work. The ideas expressed through it also. I should be paid for my work when a piece is sold, and I should be acknowledged for it when it's an inspiration for other people and talked about. Just as I think DC should be appropriately acknowledged when their work is used, and I'm more than glad to acknowledge Batman and DC. I also understand that my interpretation of an artwork can vary widely from somebody else's, and I celebrate that. That's what makes teaching at a place like Cranbrook so exciting. Meaning is contextual, and an object or image that embodies masculinity and freedom in one era can be interpreted very differently in a different time and place. Not everyone's comfortable with those changing perceptions, though, and in my experience, copyright's often used to try to limit shifts in meaning in order to protect financial investment. In my case, overtly, the lawyer for DC acted to protect their financial interests as though my costumes were a threat. I wish financially they were. Subtly, the legal actions disputing copyright ownership that Patricia mentioned, like Jeff Koons' lawsuits, caused the museum employee to run to the general counsel and try and protect the research university from my actions, and the general counsel asked me to sign the waiver, even though their mission is to support creative research. So clearly people have different interpretations and comfort with that. In conclusion, I would just like to thank the College Art Association for making this code and getting it out. I hope that you will continue to get it out, not just to the members and to groups like this, but get it to people outside of the arts who are maybe less comfortable with our comfort with interpreting culture broadly. And then last, to the artists, I know I'm one of only a couple, read this thing and then make your work be a problem for anybody that doesn't want you to change the way things are thought about, and have fun with it.
I'm going to cry.
Hi, I'm Dina Mean, and I'm here for the librarian and archival perspective. We are both the creators of cultural works as well as the supplier of cultural material to other people. So I have kind of a broader view maybe than some folks about fair use and copyright. So first, to talk about the library perspective, libraries deal mostly in published works, and issues around library copying and distribution have been widely discussed. And there is this wonderful code, which I was just provided a copy of today, Fair Use for Academic and Research Libraries, which is a code that talks about library uses. So with the Association of the leadership of the American Library Association, the Association of Research Libraries, and now with the Google settlement that we've experienced, libraries have a pretty good roadmap for copyright practice. And then although nothing is really easy when interpreting copyright, I would say that most of our copyright challenges today come from working with primary materials, at least mine do. So what I'd like to do in these few minutes is talk about copyright related to cultural materials, identify points of contact between the code and archival and special library practice, and also how copyright interacts with other rights such as privacy and publicity, and I'll provide some case studies as time allows. So, as you know, archives are made up of many collections of primary documents assembled by individuals, organizations, corporations, and really everybody. And as the code mentions, collections come in with a variety of rights at the time of donation or purchase. So depending on the collection and the use to which these will may be put, we consider copyright certainly, also the right of publicity, the right of privacy, and trademark rights. Many of the materials that come into an archival collection are things that have trademark associated with them. I will say that we also offer the capability of people who are coming to our website for the collections that are digitized to use the information or the images as part of Creative Commons. So we're not one of those ones that hold everything so close. We do make sure that things are available. So case study number one, the Fairlane Papers. This is a really wonderful collection that's made up of letters, receipts, travel literature, recipes, images, and every type of material that would be in the home of an industrialist who lived in the same house from 1914 to 1951. So the Henry Ford, of course, holds the copyright to the letters, the floor plans, the Jensen landscape drawings, wonderful, Claire Ford's recipes, and most of the images. But we may not have it for things like the travel literature or the Jenny Lind paper doll collection, which is one of my favorites. As the code mentions, tracing the ownership and permissions back through this web is problematic, but I believe that fair use can assist us when we decide what to digitize and place online. So in concert with our academic and educational mission, I think fair use gives us good foundation to stand on. Another case study, the Ford Motor Company's Sociological Department papers. These records hold information on employees who may have required extra assistance from the company. And so they have names, addresses, social security numbers, personal information that paints this wonderful detailed picture of a worker's life in the early 20th century. Much of this information may be personal protected information, and also it's a rich resource for scholars, for history scholars. We definitely own the copyright to this material, it's very clear, but as we think about digital access to the material, we'll also think about people's privacy rights. Third case study is one of my most interesting projects, the Clint Hill interview. So Clint Hill was the Secret Service agent that was assigned to Jacqueline Kennedy on November 22nd, 1963. And Mr. Hill came to the Henry Ford in 2013 as part of our Kennedy Remembrance, and he agreed to do oral history. Although our interview was focused on the Lincoln limousine, its performance, features, design, things like that, the events of the day are definitely intertwined in this interview, and it's a very powerful thing. We ask for all rights when we collect interviews, and we collect oral history interviews. And for this interview, we did receive them all, which including the right of publicity and copyright, right of privacy, everything. So this greatly enhances the future of use of the interview. So going forward, we'll continue to try for all possible rights, and hopefully these old practices will not continue. So Just in summary, archives and special collections frequently acquire material with a variety of rights. We also hold collections that were acquired so long ago that there were various professional practices regarding the assignment and the procurement of rights. Maybe we didn't always ask. It's fascinating work, and every day is a challenge, but I would say that the code will help us tremendously. And thank you for your attention.
So that's great, and I love that what you mentioned about getting all the rights that you could, and in fact, in this case, all of them, for that interview. And just want to mention that museums, this is a trend in museums now too, at least I can think of one, the Brooklyn Museum, which now, whenever they acquire a work, whether it's by gift or purchase, try to request and try to get as many rights as possible. And they're even going backwards to works in the collection and reaching out to, if it's a contemporary artist or someone they can easily reach, to get those rights, so that in the future, in perpetuity, so that they don't have to worry about it in the future, which is a great idea.
I'm Terry Segal. I'm the Associate Registrar at the DIA. I did not prepare a written presentation, so if my thoughts are all over the place, I apologize for that. But I wanted to start by saying that I know there are some registrars in the audience, and for those of you who don't know registrars, we are very detail organized thinking people. So for about a week before this presentation, I went through every document I had in my files about copyright, every presentation I had attended, reviewed all my notes. And then suddenly I woke up this morning and I was reading the code and I thought, I didn't really have to do that, because if I follow the code, it doesn't matter whether I have the rights or whether they're copyrighted or not, because as long as we're following fair use, we don't really have to worry about that, right? So just to give you an idea, what my involvement is at the DIA, my department does not manage the rights and reproductions. Our photography department and our publications editors kind of manage those. Where the registrar comes in is in two places. As you just said, like with the Brooklyn Museum, when we acquire objects, that of course all is managed through my office, and we do have a very good non-exclusive, non-commercial license that we attempt to capture for every object that we acquire. And we follow a pretty cautious policy. We have decided, we have a policy that was written in 2006. Under that policy, we assume that anything that was created 1923 or later is probably subject to copyright. We don't go to look to see if it was published somewhere. We don't calculate when the artist of that material died. We just assume it's probably copyrighted, and we try to find the person who holds the rights to that, whether the artist is still alive or there's an estate or a foundation or whatever. And in some cases, that's pretty easy to do. I think everybody knows there's a Warhol Foundation. Certain artists and their estates are very aggressive about maintaining their rights. But for a lot of the things we get, I mean, last year we accessioned over 1,000 objects. If they're little-known artists or they're anonymous works or they're cultural works of the 20th century from Africa or somewhere, we really can't find who the owner of the copyright is. So we're not going to find someone to sign our non-exclusive license. So I think that's where the code could come in really handy for us. The other time my office gets involved is with exhibitions. And that actually ends up being pretty simple, because unfortunately, in the case of museums at least, we pretty much censor each other and ourselves, and we try to restrict the photography rights. Now, we put in our loan agreement, of course, we ask for all the rights that we would want for advertising, publicity, use on the photo panels in the exhibition, flyers, etc. Most other museums that I'm familiar with usually cross that out on the back of the loan agreement, and they say, well, that's not exactly true. They say, yes, you can do that, but they require us to get photography from their source. But it's all spelled out in the contracts, and like you said earlier, if they're restricting it and we sign that loan agreement, basically it's if you want our work of art on loan, you're going to sign this agreement, so we have to follow whatever we agree to with them. One of the most persuasive things to me about the usefulness of this code when I read it earlier today was the fact that judges are relying on these codes when they're deciding fair use cases. That if we do come to some consensus within our community, that this is going to be our custom of practice going forward, judges will take that into account possibly in deciding in our favor. The other thing that I think would be really helpful is if we get more groups to endorse this code. I talked about this with some of my colleagues at the DIA, and there's really a lot of skepticism and resistance there, and it's just been built up over decades of wrong thinking. I mean, I thought, like many of you guys did, that if it was educational, it was probably okay. I thought if you were charging money for it, it wasn't, and we've heard today that that's probably not true. So I think if we can get other groups to endorse it, like, I don't know if the AAMD has endorsed this yet, but if I had a list of those organizations that I know my colleagues at my institution listen to and respect, I would be able to get further along in convincing them that this is something we could make use of. I also wanted to mention that we are in the process of reviewing our policy because so many things have changed since 2006. I mean, it's really hard now to control. Every person who comes into the museum has a cell phone with a pretty decent camera. In fact, some of the images that people take with their phones now are better than I can take with my pretty good quality Nikon that I have. So we can't really restrict photography maybe the way we used to. The other thing that I think would be really useful, it's different than the code, but I still would like to have somebody develop a source that we could go to, I don't know, the Getty or somebody similar to what they've done with their union list of artist names or their geographic thesaurus, where you could go to a single source and find a list of all the artists who are in the public domain. I think that would be really useful. And I think that's about all I had to say.
I'm so impressed by this group. It's really impressive. I just wanted to add a couple of things to the great things you said. First of all, this question of I want to create a Creative Commons license for my material, or I want to use Creative Commons. I just want to really make sure that we're all clear. Creative Commons is a way to provide a kind of blanket license for use under certain terms when you own the copyright. So you're letting people use this. That doesn't mean it's in the public domain. It doesn't mean, as people here all know, I just want to emphasize that. It doesn't mean that it's copyright free. It means that you, the copyright holder, have taken your incredibly powerful copyright monopoly and loosened it up a little by giving people this blanket license. Can you incorporate third-party material that you are fair using into that? Yes, you can, and it happens all the time. What really helps and makes it really easy for other people to understand the terms under which you're offering it is appropriate, when it is appropriate to do so, making sure that it is labeled fair use and not your material, so that people understand what is in this document able to be used under the terms of your Creative Commons license. Also, something else, fair use applies to Creative Commons material as well. And the licenses were written that way. So you can take a Creative Commons licensed piece of work and apply fair use to it. And the other thing is that about these agreements where you've made an agreement with another body and they're going to write the terms, this is like the other situations you're in, where right now the condition, the arrangements can be draconian and difficult to work with. Negotiation is always possible. Education is always possible. Having a conversation is sometimes possible, where you might point out ways in which those default options or that boilerplate can be reset in your case, and possibly setting a precedent for the future. The other point I want to make is that everybody here is doing really great stuff with fair use already. A lot of your colleagues don't know that you're doing it. And with the Code of Best Practices, it kind of gives you permission to come out of the closet on fair use. And what that means is that other people gain strength from your courage. And with luck, a little ways down the line, people don't have to be as courageous as Mark and other people on this panel to use their fair use rights. They'll be like, yeah, of course I can do that. And that would be a wonderful place to be, a place where people use their rights under the law without having drama about it.
Are you guys just, with all the associations that you mentioned that have now come out in favor of it and donate, backing it, do you send it, are you widely just sending it to every possible group? I mean, like, I'm thinking just AAUP and AAP, are those?
We've actually made a presentation to AAUP, to their board, and we're going to their conference in Denver. Pat's going, and Linda Downs. We've done a lot of mailings to a lot of groups. We're not doing, and we continue to do that. We're looking for, we're targeting the right groups, I think, and I hope. As for endorsements, we do have endorsements and letters of support, expressions of support, and AAMD is one of them, and sent a copy to each of their members. AAM has also recommended this and put it in their library, online documents, resources. And we have several other organizations that are currently considering endorsement, and we post all of those on our website and announce them in our newsletter.
And let me say that if an organization like the American Association of University Publishers were to endorse the code, that'd be fantastic. But my jaw would drop if that happened, because it's not what they're set up to do. And this actually deals with a phrase that Diana used that I think I just want to make sure that it's clear. She was talking about using materials that people allow you to use under fair use. Many times what people are doing is allowing you, they're permitting you uses. That means that they are given their copyrights, are exercising their rights under copyright to permit you, but they are not permitting you to use fair use. Nobody permits you to use fair use. You use fair use without permission by definition. So I am never going to wait for AAUP to give anybody in the scholarly community in the visual arts permission to employ fair use, because I don't think they will. It's not in their interest, in spite of the fact that every one of those publishers knows the law very well and employs fair use at some point in their work. All of those quotes that scholars write in the text from other people's scholarship, that is all an example of fair use already. So there's no question that fair use is all over corporate practice. But they're not well served in their business by saying, go right ahead, you know? So I don't think they will, but I am actually really excited about the fact that no broker or large copyright holder has said a peep, not only since the Code of Best Practices for the Visual Arts was issued, but since any of them were issued. And we happen to know, just because I know a lot of people in the doc business, which is my scholarly area, I know that every one of the studios, of the major Hollywood studios, not only has always employed fair use, but is aggressively employing fair use, because I know the lawyer who's handling all of their fair use clearances, fair use decisions. So what they're doing is actually using the code of best practices to do that, to decide when they need to get that lawyer's letter, to sign off for the errors and omissions insurance. The errors and omissions insurers only agree to a fair use claim if it falls within the code. So a lawyer has to say, yes, this falls within the terms of this code. So we know that these businesses use this all the time. But I think it's unfair to ask any of them to sign up to say, this is fine with us. However, we do think it's super important if you know somebody on the board of directors of an organization, chat with Janet, because these personal relationships make a huge difference in an organization.
And to endorse the code, I think, means to to endorse the idea of discussing these principles and limitations. So it doesn't mean that one can always employ fair use, but it can mean that we're part of the community that is agreeing to consider these questions when we make our decisions. And I think it's true. I think I would like Pat to talk a little bit about the evolution of acceptance of these codes from her experience with other communities, because it doesn't happen overnight. We need, what are they called, early embracers? Early adapters, thank you.
This panel is full of early adopters, by the way. So if you don't need your rights, why would you use them, right? Because you're fine. Using your rights means you have a reason to need your rights. So if with settled practice that is, the visual arts are the most out of alignment group we've ever worked with in terms of employing fair use. The extremity that people go to make sure that everything has permissions, it's kind of breathtaking, especially when it runs right up against the core mission of the work. So I think that you have a practice that is very extremely biased toward copyright monopoly currently, not among the artists. The artists overwhelmingly, although you can take a look at the survey from the issues report, the artists by and large have a pretty solid, grounded understanding of the fair use because they're already thinking in transformative ways. Oh gosh, one other point about transformative. I might have misled people, and I just wanted to apologize about the educational stuff. Educational is not a pass in general, but education is typically a fair use. But why is it typically a fair use? It's typically a fair use because usually educational is transformative. Usually what you're doing with this material is teaching people about it, which is different from the reason that it was originally created. So that's why I say the umbrella you want to go under is not educational, but partly because there are educational exemptions that have other limitations around them. It can get confusing, but stick with transformative. But educational is a really great, usually when people are using work educationally, it is a transformative use. But so when we see changes as a result of employing fair use, we see people who most need their access to these rights going after them first. So Kirby Dick made a movie about the Motion Picture Association and criticizing it. He used 134 motion picture clips. None of them were cleared. He was a guy, he was in the very first wave of people after the documentary filmmakers' statement was signed. And he needed to, because his movie could not have been made without employing fair use, because he was saying bad things about the Motion Picture Association. And when you license a clip from one of the major studios, it actually comes with a clause that says not only will you use it only for the purpose that you have agreed to use it for, but you will not say anything bad about the motion picture industry either. So he just couldn't say this, so he was so sure he was going to be on the vanguard of troublemaking, and of course he didn't get into any trouble at all. But he was able to refer to the code Another guy who went up at the same time releasing his film, Hip Hop, Beyond Beats and Rhymes, a critique of misogyny in hip hop. Entire movie, wall to wall, hip hop, used for a purpose that none of the hip hop artists in question wanted to be used for. Another film that went up at the same time, Outfoxed by Robert Greenwald, a critique of Fox News, which, believe me, was not going to license their film to a left-wing filmmaker in order to say bad things about them. 3 examples of cases where these people absolutely had to employ their fair use rights or the whole movie doesn't exist. So they're the first out of the box. Nothing bad happens to them. They all get on broadcast. They all get, errors and omissions insurance. Meanwhile, everybody else is going, yeah, but those people, they're kind of gunslingers. They're kind of like really way out there. And HBO is saying, that's fine, we've got lots of money, just clear everything. To the people that they take on. And some other things happen. First of all, people see that nothing bad happens to the people who went out on the edge the first time. And they're like, okay, well, maybe if I ever have a reason, I could do that. And then somebody else starts making, non-HBO people start making films that come in at much lower budgets because now they don't have to clear everything. And HBO starts saying, well, maybe sometimes we could use fair use. It would be a lot cheaper. Like this movie would have cost $100,000 less if we'd actually used our rights. Okay, well, maybe we should. And they actually get a film that. So then suddenly it's not just these crazy filmmakers who happen to get picked up by distributors. They got picked up by major distributors, IFC and PBS. But it's also those same entities, PBS, IFC, HBO, that are suddenly incorporating this practice. And then other people are, so now the filmmakers are coming in saying, well, industry practices, you don't do that. Suddenly industry practice is diverse. And now, of course, industry practice is 180-degree changed. But the fact that some people did it made a huge difference to other people whose organizations were either more well-heeled or more risk-averse. And that's why I say having people who undertook what they regard as a risk to do this work and did it and they're fine, that makes a huge difference to the next people. And it is a process. As one of the exciting things about this study we did with the documentary filmmakers 10 years on is that we can now show filmmakers themselves that the field has changed. Last year, I still had people teaching in film programs who were telling me, well, I love your code and I've used it, but I can't teach it because I need to teach industry practice. I can't teach, this stuff. And now I was able to say to them, actually, it is industry practice because we've been able to document it. But it is a process, and it's especially a process when you're in a community like yours where there's a huge amount depending on personal relationships and goodwill. And that's where I really want to just go back to this thing about not getting away with things, but being in the center of the law. Because if what you understand you're doing is encouraged by the law in order to generate new culture according to what the mission of your work is, that is a place of dignity. And it's not, it's not saying, the ethical thing to do would be this other thing, but the law lets me do that. This actually is something that is entirely appropriate to do. And I think that as that conversation begins in the field, and it begins to normalize practice, and your reputational risk you change, and the risk of damaging relationships also changes.
Okay, thank you all very, very much for great presentations. We have about 20 minutes left for questions. We're going to use 2 of the microphones throughout the audience. So Tricia and Elizabeth, can you come forward to grab some mics? Okay, if you do have a question or a comment, could you just raise your hand and wait for a mic to get to you? That way everybody can hear your question. So we can have our first one right over there.
Yes, I have a question. You asked about label of fair use or labeling fair use. You mentioned that previously about 5 minutes ago, and I wanted some clarity on that.
So I think what I was responding to was people permitting you fair use or allowing you fair use. So when somebody is allowing you a use of their material, it's actually not fair use. They are permitting you to do that because they have some control over that material where they have the right to do that. When you employ fair use, you just go ahead and use it. There's no permission.
I have very much appreciated your comments today. It's been a real education. We have a digital database, and it's Great Lake Chips, and we often get inquiries to use the images and giving people copyright, and we've never denied it. Are we better served at this point to respond by saying, as you have described it, under fair use, you do not need our university's permission to use the image?
So one of the things that large copyright holders, major media companies, are now doing when documentary filmmakers come to them and say, can I use this clip? That's a real problem for a lot of media companies because they don't necessarily own all of the rights in that because they contracted with other people for some of it. And so they actually can't give permission. Where they could give permission, they do not want the transactional costs of dealing with these low rent people. So there's a strong motivation in the media companies to use this doc filmmaker statement, their own code. And what often people will say is, can't answer that question for you, but have you taken a look at this other document and you decide. I'm not telling you your rights. And if I were a rights holder and somebody came to me and said, I'd like to get permission from you to use this, and for one reason or another it wasn't worth it to me, or I couldn't give them permission, I think I wouldn't tell them what their rights were, because you don't know how they're going to use it. And even if they were told you generally, well, I just want to use this in teaching or something, it's still a question of how they're going to use it in teaching. Diana just did a beautiful job of describing these limitations. So I wouldn't take any responsibility for telling people their rights, but I would think it would be a terrific thing to be able to point them to this code and say, this is something else you might want to know about. And if there's a place on the website where there's a contact information for get hold of us for permissions here, you might also want to put a link to the code and say, and if you're thinking about permissions, also take a look at this. Did that answer your question?
I think so.
Hi, I just wanted to ask you to clarify for the audience something that I hear people saying that is actually a misuse of terms. I'm someone who teaches faculty about copyright and how to hold on to their rights as authors, and the idea of not giving your copyright away, but you're licensing. And a lot of audience members have been saying that I'm going to be giving them copyright, or we're asking for their copyright, when I think they're actually saying licensing. We will license it. So if you could just clarify that for the audience so they understand the difference between that. So as opposed to giving when a academic scholar gives away their all of their copyrights, they don't own anything anymore. But you can actually just license those rights, and the original owner still owns the copyright. So that's where the audience seems to be misunderstanding, is that they're not giving away the rights to the items they have, they're licensing them to people.
So you could license something if you have the rights to it, but you can't license it if you don't have the rights to it, because you don't have the right to license something you don't have the rights to. So if you have the copyright, you can then entertain whether you want to license something. But you can't if you don't, or even if you don't own all the rights to it. So scholars can't give a permission, for instance, if somebody comes to them and says, I want to put your chapter into my anthology, they can't say yes if they already gave their copyright away to a publisher. The publisher is going to be able to say yes or no. And this is why you'd really, as a scholar, like to take a very good look at your contracts. I mean, if you could possibly hold on to your copyright, that'd be great. Often scholars, particularly when they're beginning, are not able to negotiate that. But it might be possible to negotiate terms of that contract that allow them some rights, or alternatively to limit the amount of copyright that somebody has. Is that?
Fascinating discussion. Thank each of you. This is slightly off topic, but a gentleman earlier asked a question about logo, and I wondered if the association has any guidance for other areas of the law, such as trademark and trade dress, that might come into play in the visual arts.
So it's really unlikely that you're going to run into trademark problems doing most of what you do, but could we get the mic back? Because I'd just like to know, are you encountering trademark problems?
No, I'm actually an attorney, but not a
Oh, never mind. Then go ahead. Go on about trademark law.
No, I just wondered if that was an area in which you had some published guidance or recommendations, or have you seen problems, for example, with a piece of artwork that more or less disparages a trademark or uses the trademark in a way that is going to give rise to an infringement claim?
So there are things you could do with somebody else's trademark that really would be very bad in trademark law. Like you could imply that you were covered under that trademark. Like you put up a Starbucks sign on your coffee shop. Not good. Because now people will think it's Starbucks. But you put a Starbucks sign into your collage about the commercialization of food in America, that's not a problem, because trademark law exists to protect the value of the trademark within commerce. So usually what you're doing is merely referring to them. So people are confused about logos. There are copyrights in logos, but they're not significant in the uses that I think you guys are putting them to. People do get confused between trademark and copyright. That's why you see all those trademarks pixeled out of shows on cable TV. It's because some production assistant said, "Wow, they told me I have to make sure and get everything cleared in this documentary, and there's an Exxon sign in there." So, but a trademark is usually not something you need to consider. And I'm just going to turn it back to our attorney.
No, I totally agree with you, but I just thought, since the gentleman had raised the question, and I know it's something that might be in the minds of the students and the artists as to whether they're going to run into a problem in that area. So I think you've elucidated that very well. Thank you.
There is a document on our website, I don't think it's on CAA's website yet, called Yes You Can. It's a list of issues that are not copyright issues, and it was designed for documentary filmmakers, but it's actually very applicable to elsewhere. Issues that come up about releases, about shooting pictures outside from a public place, and so on. And if Greg cares, I can send that link around to people who were here.
We've got a couple more over here. Hi, I have a quick question. Hopefully you don't mind if I ask for your opinion on something that I'm working with a professor who's putting up an exhibit in a museum, and she wanted to use some images from National Geographic that I think one of our U of M professors took the pictures in the 60s. So I didn't even want to ask National Geographic, but she was really playing it safe and said maybe we should. And so now they're saying they want a bunch of money. And I really feel like it is fair use. But what do you think would happen now that they know we want to do this? And if I go back to them and say, no, we're not going to pay you, it's fair use.
So this is a really great question, and it comes up all the time in lots and lots of different circumstances. Have I given away my fair use rights because I asked for permission? And the answer is unequivocally no. You have not given up your fair use rights, and sometimes you may even have strengthened your fair use rights. Now, I'm not going to tell you about whether you should use those Nat Geo pictures. What I would say to you is look at Category 3 on museum exhibitions and see how you think the uses of those photographs line up with the rationale. But in terms of asking, there's a lawsuit that's just delicious. It's called Dorling Kindersley. It's actually really fun to read. The judge in the appeals court decision had so much fun writing it. And it's Dorling Kindersley versus Bill Graham. And these people in a purely commercial publishing house decided to publish a concert-by-concert chronology of the history of the Grateful Dead, of great interest to deadheads everywhere. And they licensed a lot of stuff. And they went to Bill Graham and said, we want some posters from the Fillmore in the 70s when the Dead were playing at the Fillmore. And he said no. For whatever reason, he said no. And they were like, well, we're going to fair use it. And he said, well, then I'm going to sue you. They went ahead and fair used it. They put in 2 pictures of posters on a page where there's a number of other pictures as well. The whole page is in black and white. And he sued, and the district court said, this is just an unbelievably slam dunk fair use case. This is a piece of historical work. And now, note that it's the Grateful Dead, and this is like a highly commercial publication. That doesn't matter in fair use law. They will protect all kinds of speech, even bad speech, even speech in very bad taste. So the district court judge said, this is just a very clear fair use. This is a transformative purpose. They're using it for a different purpose. They, by the way, used an appropriate amount. They didn't even put it in color, they could have even had a good argument for putting it in color, except it would probably be expensive for them. And it's small, and you're not going to make a poster out of this, and no. So Bill Graham appealed it, and the appeals court came down so hard on him. They wrote, it is really a shame that Bill Graham did not get better counsel, who could have advised him not to bring this lawsuit, wasting the court's time, on and on, because it was just so obvious that this was a transformative use and appropriate amount. And they had gone to him to ask if they could clear it first. So if you're at all confused about that, no, you're fine to be able to use your fair use rights.
Can you talk a little bit about institutions as we move through this next phase and in getting this out there, about how we basically can cover ourselves? So I worked in an institution where when we were talking about fair use, we had a checklist, and we really had to document for the files when we wanted, and this was in the absence of, the guidelines. But, when we're talking about these issues, if we use takedown language online, or should we be, saying like we are asserting our fair use and using these copyright materials, or is it better just, we might have the backup internally, but maybe not broadcast that? Or can you talk a little bit more about that?
So you're talking about an archive and a collection?
Yeah.
So this is where the limitations in the code are really helpful to you, because I think if I wanted to be super comfortable, I think you can't be completely safe whenever you use your rights. You never know. Most of fair use law is not actually between large corporations, because large corporations tend not to sue at all. It's cranky people a lot in estates. The Elvis Presley estate, Bill Graham, Yoko Ono. But you never know when a cranky person will appear. So nobody's going to say, you're going to be 100% safe doing this. If you want to be 100% safe, then lock yourself in that box. But if you have a reason to use your rights, then what I would do is, first of all, ask myself, in good faith, am I within all of these limitations? Have I stayed within what the field regards as the best practice? And the other thing I would say is, how have I documented internally that we believe we are in conformity with these best practices? If you do that at the time, I think you have really great evidence, should anyone contest it, about what your intentions were and what your function was in doing that. The other thing that people talk about in collections a lot, and not just here, there's a really nice code of best practices for orphan works and collections. What people talk about a lot is it's really important to make clear that if somebody has any kind of question or issue, here's how to get hold of us, and to respond to people in a timely way, and to leave a record that you responded to them in a timely way. Overwhelmingly, what people tell us as a result of the Librarians Code, the Orphan Works Code, is that that this has been very valuable to them, not because anybody has complained or wanted a takedown, but because people want more information and they want to tell you about their uncle whose picture that was, and they want to add to the metadata. So I think those are things that we learned from librarians, from archivists, and from visual arts professionals, are the really important things that they think are important to do. Those are not things that I'm recommending to you myself.
I think we have time for one final question. Okay, we're in the front.
Yes, hello. Going back to that Starbucks logo, other logos, I've been seeing a lot of postcards with logos on them for sale, but by artists, by a lot of Detroit artists, and different items, different things, magnets, coasters. What about that?
So, what I can't tell you, what I don't know is, are you talking about an artist who made a piece of work and is now selling that piece of work?
Yes.
So that artist has employed, let's say the artist has licensed the material and is now selling that material. He's got no issues. Say the artist has created this work using fair use. Does he have a right to put that work that is incorporating fair use onto the market? Yes, he does. He can, put it on a T-shirt. He can do what he wants to. So the question would be, in that case, is it a defensible artistic fair use? So then you would go to the section on art and fair use in the code and see what you think about that checklist. If somebody has a big sign, I'm just going to say Starbucks again, Starbucks, and the poster, the postcard is basically a big Starbucks sign. It's a little hard to see why this is art. It looks sort of, I don't know why anybody would want a Starbucks postcard, but let's just say.
As an example, I see a lot of the sports around town with the same kind of thing, and I see it so often. I'm just wondering how they can do that.
So a logo of, what's a Detroit sports team?
Tigers, Lions,
Tigers.
Red Wings.
So you could put a Tigers magnet, a Tigers postcard. And what that means to people is, go Tigers. I support Tigers. I like the Tigers logo. That sounds like a substitution of the original thing, rather than adding any value. It doesn't sound very artistic to me. It doesn't sound like you did any art there. And so you might go in and say, not only is this art, this is appropriative art in the same style as Sherry Levine. And that would be a story you could maybe tell. But if what you were doing was putting those postcards in all over the airport and the bus terminals and wherever else people want to take souvenirs of Detroit, and you didn't license any of that from your major league sports team, I think you'd get real pushback from them, because they'd be like, how come we're the Tigers and you're not, and you're taking the money and not giving any of it to us, which is a completely reasonable question, even though I hate to say a nice thing about Major League Sports and copyright. Am I making sense to you?
Yeah, I just see it so much, I had to wonder.
Okay, we're going to squeeze in just one more question.
Okay, I'm hoping this kind of falls into the area of arts. So I have taken a picture of the table, of you sitting at the table here. I know who you are, and you are, and you are, and I can't find you or you or you. So can I, in my digital archive at a university library, post your picture with only his permission and her permission?
You don't need our permission. And you own the copyright from the picture. Just put it in our archive, make us famous.
I'm sorry, what?
Put it in the archive, make us famous.
Oh, okay.
And then if you don't know who three of the people are, you can put that on your website and say, can anybody identify those three other people? Marcos, you can put it on Facebook.
Well, thank you very much. I think we could have gone on another 2 hours with these questions that all of us grapple with on a daily basis. But I really want to thank, first of all, Janet from the College Art Association and Pat for flying in today, again, through the generosity of the Mellon Foundation to join us, and the other 5 speakers that all thoughtfully digested this fair use document and then gave us their reactions to it. And thank all of you for joining us today and your comments.